it being mommy's fault that the family has to no longer live together and that they won't be a family anymore. And we're asking that this court require the defendant to vacate the marital home forthwith, and that any necessary parenting exchanges, he come back for that and not for other reasons.
While the real estate was the plaintiff's premarital property, it is now in the name of both parties. It has been mortgaged, and there's been significant work done to the home during the marriage, not just the kitchen renovation that my client has been working on. He has done significant work to this home to increase its value.
Mom filed for divorce 5 months ago, and Dad failed to file any response or take any other legal action.
Court will note the appearance of Ms. Thomas on behalf of the plaintiff, Ms. Podolsky on behalf of defendant. We have two motions before the court today. The plaintiff's motion for custody, support, parenting time, exclusive use. Defendant's motion to set aside default. Ms. Thomas.
We filed a complaint for divorce almost 5 months ago, and the defendant was served on or about November 1st, 2023. At that time, the oldest child was 8 and the twins were only 4. After the defendant failed to file any response or take any other legal action, a default was entered, and it wasn't entered actually until November 28th, which actually allowed the defendant 28 days to respond rather than the 21 days that he was allotted by the court rule. In the complaint for divorce, plaintiff requested joint legal and physical custody with the parties sharing parenting time. Said complaint alleges the parties are both good parents, so it's very confusing why, after 4 months of doing nothing, defendant is now requesting that the default be set aside. Unfortunately, during those 4 months, however, the parties' relationship has broken down much further, and now there is blame being taunted by defendant and him telling the kids inappropriate things about it being mommy's fault that the family has to no longer live together and that they won't be a family anymore. He's in his answer to our motion, that I'm not quite sure how that got filed without the default being set aside, but whatever. In that answer, it indicates that he's been working on this kitchen project. In reality, he apparently tore the kitchen apart a couple of years ago and had not done anything since then. And after he was served with papers, he actually started working on the kitchen project. So as stated in the answer, it's pretty misleading. But even times when he wasn't working on the kitchen project. In fact, the arguing and name calling and threats have increased to the point where the home is toxic now with both parties living there. These children are very little, and they're at a pretty tender age. They shouldn't have to be in a situation where one parent puts the other one against each other. And that's not to say that there's no fault on the part of my client either. That's not what we're saying. It's just not a good situation. It's very toxic. The children should not be knowing anything about what's going on about the situation other than mommy and daddy aren't going to live together. They both love them and they're going to move on. It's not their fault. This is not something that the kids should have to be going through. Unfortunately, this is not the situation that is going on with the children. So frankly, we're like a month away from the normal time of the divorce, and the parties would be separating anyway. And so we are certainly believing that defendants continued, whether it's denial or just refusal, to believe he is not moving, is not looking at reality. Defendant had clear knowledge of plaintiff's intent to keep her premarital home, not only in her words, but it was also clear from her complaint. Her position was that each party keep their premarital assets. Defendant appears to rely on his stated belief that he thought the parties would reconcile, but that was never told to him by plaintiff, nor were her actions such a matter that he should have believed that they were going to reconcile. Defendant basically sat on his laurels and now wants a do-over. 112 days after is when Ms. Podolsky filed an appearance. Your Honor, plaintiff is asking to do not reward defendant for his inaction. We're simply wanting to finalize the default judgment of divorce. It's almost, I was waiting for one piece of information, which we now have. That's done. Plaintiff intends the parties will have equal parenting time as well as joint legal custody, joint physical custody, as was stated in her initial pleading, and as what it appears from the answer that was filed by the defendant, that he's asking for the same thing. She does believe that with these kids being so young, that a week is too long for the parties to go without seeing the children, and more importantly, the children without seeing their parents. So she has asked that we set it up on a, so defendant dad would have Monday, Tuesday, mom would have Wednesday, Thursday, and then they each enjoy like an extended long alternate weekend. Based upon the defendant's allegations and the time he was working and his hourly rate, we had prepared child support calculation when we filed the initial complaint for divorce. And that was in conjunction with that and the plaintiff's pay records. The amount of child support, I believe, from that calculation was $32 payable to mom. She has requested certainly during this temporary time that no support be paid. It's pretty negligible amount, and it's almost not worthwhile to have front of the court do that. So she's fine with not having it at all. Ironically, it appears that defendants made the same request in his answer to the complaint as what the plaintiff did in her complaint itself. He desires a divorce, joint legal custody, joint physical custody, property equitably divided, child support pursuant to the formula. It's the same basic thing. Your Honor, we're merely asking this court to uphold its prior order of default, free these children from the circumstances and the situation that they're living in with the drama, the ugly words, the actions, those kinds of things. And again, it's on the part of both parents. Not to put either parent in a bad light for the children and living together, that's happening. We're requesting permanent and quite frankly, temporary and quite frankly, permanent legal custody and joint physical custody. We also are requesting that on a temporary basis, no child support. And if we need to figure that out and calculate that again, that's fine. I'm willing to work with Kelly no matter what. But at this point, it is not a good situation. We're asking that this court require the defendant to vacate the marital home forthwith, and that any necessary parenting exchanges, he come back for that and not for other reasons. And frankly, as both this court and counsel are aware, this is a situation where if the judgment, which would be entered within the next 30-ish days, if it's not equitable and the defendant believes that, then he certainly has alternate remedies that he can take at that time. So we're simply asking that we have an order in place that identifies the temporary situation, joint legal, joint physical, an abeyance of child support, and the plaintiff to have exclusive use of the marital home in dependency, and then a judgment would be entered. I believe it's just over a month now is where we're at as far as timing.
Okay, thank you. Ms. Podolsky?
Thank you, Your Honor. There are several issues to address here, the first being our motion to set aside the default. As stated in our motion, my client truly believed that these parties would reconcile. He did not believe that the divorce was going to get to this point where it's so close to finalization. And unfortunately, it was the motion filed by plaintiff asking him to move from the marital home now that served as the wake-up call that this is unfortunately what is going to happen to their relationship, that this divorce is not going to be dismissed. As Ms. Thomas stated, it is correct that we are in agreement on the issues of custody, the parenting time schedule that they proposed, and child support. Again, we would just exchange those pay stubs, and if child support is as negligible as they state, then yes, that would be an agreeable solution. However, this case is more than just about custody, parenting time, and child support. As Ms. Thomas stated, this is a court of equity, and these parties do have significant property. While the real estate was the plaintiff's premarital property, it is now in the name of both parties. It has been mortgaged, and there's been significant work done to the home during the marriage, not just the kitchen renovation that my client has been working on. He has done significant work to this home to increase its value. So yes, this is a court of equity, but why would we wait for a judgment of divorce to enter to be objected to if it's not equitable, when we can exchange the verified financial forms, we can attend a mediation on these issues of the division of property and debt. So we're asking the court to set aside the default, or in the alternative, order the parties to exchange the verified financial form, attend a mediation in mid to late April, and we'd still be at that 6-month mark. We would not be causing undue burden on the court and judicial economy. So we're asking the court to set aside that default or order that mediation. As it relates to the party's current living situation, again, my client was not thinking that this was going to get to this point, that this divorce was going to happen. He truly thought these parties were going to reconcile. It is his firm belief that these parties can continue to live together with these minor children during these last few months of the pendency of the divorce. That will afford my client an opportunity to find a place to live. This motion was filed and a date sprung on him. Thankfully, council did allow us an adjournment to be able to file this answer. However, in this current economy, it is difficult for him to find a rental or a new place to purchase. He would rather not have to move a few times, but just the one time. So we're asking the court to not order exclusive use today, order that the parties may both remain in the home, and order the parties to act with a sense of decorum, especially around the children. No swearing, no fighting, no screaming, no arguing, and keeping this peaceful in these last few months. But we do not believe it is necessary to order exclusive use today. All of those issues can be resolved at mediation, move out dates and the like. So we're asking the court to deny that portion of plaintiff's motion today.
Okay, thank you. Well, in this particular case, there's no dispute as it relates to custody. So on a temporary basis, the court will grant the parties joint legal and joint physical custody. There's no dispute on the parenting time. The court will incorporate the parenting time schedule from paragraph 4 of the plaintiff's motion. The parties apparently have agreed to no child support. However, court doesn't know if there's public assistance involved. The court would agree that neither party would have to pay child support, provided there is no public assistance involved in this particular matter. The court will grant to the plaintiff exclusive use of the house and would order that the defendant would vacate 21 days from today's date. As it relates to the defendant's motion, the court notes that the defendant has stated, well, that he believed that the parties would reconcile. Well, that doesn't rise to good cause to set aside default. He didn't file anything for 112 days after the default, so the court will deny the motion to set aside the default. However, the court will allow the defendant participate in disputed matters in this case, and the court will order the matter to mediation in April 2024. I'll leave it up to the parties to agree upon who the mediator will be. As Ms. Podolsky has stated, the court would hope that the parties would be civil. Well, that, again, the court over a period of time found that to be wishful thinking, is that parties are not always civil to each other, and plaintiff has made out sufficient cause to establish that there is contention, et cetera, in the home for granting exclusive use, and that's why the court did it. So that will be the order. I'll ask Ms. Thomas that you would prepare that and submit under 7 day.
Thank you, Your Honor.
Okay. Thank you both. You're free to go. Have a good day.